my guest. Now, Senior Advocate Abhishek Manu Singhvi, appearing for the state of West Bengal, and DGP Rajiv Kumar made a forceful intervention. If notice is issued, it must be made clear that there is strong opposition to the maintainability of this petition. He argued the petition should only be entertained in exceptional circumstances where the ED is completely helpless. A threshold, he contended, has not been met here. Singhvi raised the issue of forum shopping, pointing out that the ED is pursuing essentially the same prayers in both the Calcutta High Court and the Supreme Court simultaneously. I also raised the issue of forum shopping, where the prayers are same in HC and SC. Yes, you had an issue on January 9, but that cannot be an excuse to ride two different horses. He acknowledged the emotional undercurrents in the courtroom, but urged focus on legal propriety. Sometimes emotions go out of hand, and we understand what the court is saying. Relevant test is yesterday. Now, referring to the Calcutta High Court's proceedings on January 14, where the ED confirmed nothing was seized from IPAC premises, the bench responded firmly to the reference to emotions. Emotions cannot go out of hand repeatedly. Solicitor General Tushar Mehta for the ED interjected sharply in an orchestrated manner, implying the alleged obstruction during the January 8 raids at IPAC's Kolkata office and residence was deliberate and coordinated by state authorities. I have Sambhav Sharma joining me. Sambhav, what more can you tell us?
Well, absolutely. These are the arguments being made in the Supreme Court as we speak. Now, all these senior advocates, including Senior Advocate Abhishek Manu Singhvi, Senior Advocate Kapil Sibal, and also Solicitor General Tushar Mehta, everybody present in the courtroom making submissions for different parties. And if, as you rightly pointed out, Senior Advocate Abhishek Manu Singhvi has argued that any notice, if issued, as the Supreme Court earlier hinted that they will issue a notice, they could issue a notice rather. So here, Senior Advocate Abhishek Manu Singhvi is saying that a notice should clarify strong opposition to the maintainability, and also it's allowed only in exceptional cases where enforcement directorate is helpless. So here, Abhishek Manu Singhvi is saying that it doesn't seem that ED is helpless. But a notice could be issued in exceptional circumstances where ED is helpless. And also, Singhvi has raised the issue of forum shopping, noting that some prayers filed in both the High Court and the Supreme Court. So there is some kind of forum shopping going on. And to this, a Solicitor General has contended that actions there were orchestrated in nature. And the Supreme Court has cautioned that emotions cannot repeatedly go out of hand during proceedings. So obviously, an emotionally charged hearing going on in the Supreme Court, and Supreme Court has cautioned, the two-judge bench is cautioning that emotions cannot repeatedly get out of hand in the court proceedings. Senior Advocate Kapil Sibal, on the other hand, has said that he's talking about Section 66, Clause 2 and he's saying that Section 66, Clause 2 requires offences to be reported to state probe machinery, noting ED's Panchanama contradicts its claim of trespassing. So there is a kind of contradiction in the Enforcement Directorate's claim, is what Senior Advocate Kapil Sibal is putting before the Supreme Court. So three big lawyers, top lawyers of the Supreme Court, Abhishek Manu Singhvi, Kapil Sibal, and Solicitor General Tushar Mehta for Enforcement Directorate, everybody is making submissions in the Supreme Court. It seems, submissions in the top court is going on for almost an hour on this very crucial case, and it is to be seen whether the Supreme Court in this particular case issues notice or what the top court says next, because the hearing in the Supreme Court is going on in full swing. All top lawyers are making submissions in the Supreme Court. And also, Abhishek Manu Singhvi is saying, please consider that we put in a reply without notice. Supreme Court said that let it be done in a legal way. So arguments are being made. It seems that the hearing could conclude in coming few minutes because it's likely that Supreme Court could issue notice. Now, another senior advocate, Shyam Diwan, is making submission, and he is saying what has happened in subject to Article 226 of the court. Article 226 of Indian Constitution deals with the powers of the High Court under the writ jurisdiction. So he's talking about the senior advocate Shyam Diwan is talking about Article 26 of Indian Constitution, which gives power to the High Court, and also I mean, January 9th disruption should not have a lingering effect for this court to issue notice. Another important argument. Now, another big update from the Supreme Court. Additional Solicitor General S.V. Raju, who made submissions in the Calcutta High Court yesterday, is making submission in the Supreme Court. ASD is saying that recording of an FIR require a cognizable offence to be made out. Prima facie, case of disclosing cognizable offence is enough for FIR. Hearing an accused is unheard of before registering the FIR, and this is a case of theft. ASD is again putting out the similar kind of argument in the Supreme Court. He is saying, ASD S.V. Raju in the Supreme Court is saying that this is the case of theft, robbery, dacoity, and this is a simple case of theft which is made out. This is settled law. He's talking about one of the judgments or earlier judgments of the court, the Lalita Kumari case, and he is saying that as per Lalita Kumari's case, this is a settled law. And what happened there in the West Bengal, it was the case of theft, it was a case of robbery, it was a case of dacoity, and it's a simple case of theft which is made out. So an FIR should be registered in this case. And remember, this is exactly the petition of the Enforcement Directorate. One, filing an FIR, seeking permission to file an FIR, also to let the Central Bureau of Investigation investigate this whole, this particular case in the state of West Bengal. Now it is to be seen what the Supreme Court says next in this case, because the hearing is going on, and all the top lawyers, including Senior Advocate Kapil Sibal, Senior Advocate Abhishek Manu Singhvi, Solicitor General Tushar Mehta for Enforcement Directorate, and now ASD.
Right, Sambhav, stay on with me. Now, on the Calcutta High Court's order and forum shopping, Senior Advocate Abhishek Manu Singhvi stated that High Court, with regard to Committee of Courts, passed an order, not disputing that. So that is forum shopping, and then we come to the Panchnama part, reiterating that the ED is pursuing parallel proceedings with identical prayers in the High Court and Supreme Court. Turning to the core document, he said that what is relevant is this: either you are lying or your petition is lying. Search was conducted in peaceful and orderly manner. It is recorded. The bench appeared to acknowledge the record. This shows they've done so peacefully. Singhvi pressed the contradiction. I'm saying with this Panchnama, what you're projecting in the plea is false, or your Panchnama is false. So obstruction can't do search, etc. It's all false, arguing that the ED's own search Panchnama incident report memo records the operation as peaceful and orderly, directly contradicting the agency's claims of wrongful restraint, forcible removal of devices and documents, and inability to complete the search on advance notice. Now, as she said, we were only informed by a casual email saying 11:30 a.m. You started searching at 6:45 a.m., highlighting that the ED began the raid hours earlier than the time communicated to state authorities, undermining claims of deliberate obstruction by police or the Chief Minister. I want to go across to Advocate Pramod Kumar. He's an advocate, of course, at the Supreme Court. Now, Mr. Kumar, all of these developments that are happening, Kapil Sibal's come in, Manu Singhvi, what would you like to say?
First of all, ma'am, very clear case. Supreme Court is very serious in this issue. And Honorable Justice Prashant Kumar Mishra and Honorable Justice Bipul Pancholi was surprised to see this plea. A constitutional body like a Chief Minister of West Bengal personally interfered and hindrance in this, raid by ED. And it is the first time it's happened in India. A constitutional body is interfering in the, central agency for doing their constitutional work under the ED provision. So the court also saw what happened yesterday in West Bengal High Court, Kolkata High Court. The TMC persons and their manpower is just disturbing the court procedure. So the court was shocking how the TMC person is lobbying everywhere in West Bengal. Now the ASG, Mr. Tushar Mehta, Solicitor General, argued if such type of a function is going on in any interference in a central function, then the havoc will create in India and no law enforcement agency will properly work according to law. I think the ED also seeks CBI investigation against Mamta and West Bengal police officer who is involved in this such a crucial event done by the ED, like DGP Rajiv Kumar, Kolkata Police Commissioner Manoj Kumar Verma, and South Kolkata by the Priyabharta Roy. We also follow last week when the ED official conducting searches at the Office of Indian Political Action Committee, IPAC in Kolkata, the Chief Minister Mamta Banerjee, who himself interfered and trespassing the premises of the IPAC and snatched and theft the so many documents, important documents, which is just related to a coal mine scam that amount about 2,700 crores of the public money. So I think this is very serious. So the another side, the Kapil Sibal, Senior Advocate, and Abhishek Manu Singhvi says why it's needed in this time when the election is commencing and it is in the door of the West Bengal. So at that stage, this is not a proper to conducting in a coal scam, but ED is just doing some creating havoc in West Bengal and defaming and demeaning the Chief Minister's function. So, and that stage, the Honorable Justice Mishra also want to know, yes, this IPAC is also related to this Prashant, who was always, earlier the supervision of this, elections information. So today, the Justice Mishra also asked why tomorrow it can be another things that happen, such type of a problem created by the state government to the central agency, and the whole law enforcement functions will be massive, and no even a law enforcement agency will be doing their performance in a well manner. And you can say in the other side, the constitutional body, our system, will be create a very dangerous position. So in that context, Singhvi also refer Panchanama, either Panchanama is lying or ED petition is also lying. At that stage, the SG Senior Advocate Mehta also informed the first and only intimation came from the casual email that some Panchanama, they are just threatened to the ED officials, not mentioning the whole system, whole thing in Panchanama. So the court is very serious in this issue, and I think the court is in position in future this type of serious issue will not happen. So there must be taken action, and presently I think the matter is going on, and Kapil Sibal is also arguing the data kept with IPAC, and IPAC is doing some supervisory duty of the Mamata Banerjee TMC party for the election information. So after all, I think the Honorable Justice Mishra and Honorable Pancholi also in the view, this is a very serious issue and action may be taken against this TMC and especially the Chief Minister of West Bengal, Mr. Mamata Banerjee, and the other police officials in the connivance of the other police officials like DGP and Commissioner of Police and other commissioners also involved in this case. So departmental actions will be also taken, or the FIR will be also lodged against this person, because this is very serious issue, and in future this type of event is not continue in near future. So I think the Supreme Court is very serious, and the Supreme Court is taking very appropriate action against this person, so that the message will go in the public. At least the law is enforcement agency has a very free will to take their own course in India. Thanks.
All right, I'd request all my guests to stay on with me now to Senior Advocate A.M. Singhvi's statement. SG Tushar Mehta replied that an email is an email. In a sharp rebuttal, Senior Advocate A.M. Singhvi said that this is just an attempt to cover track and create a paper trail. Senior Advocate Abhishek Manu Singhvi, continuing for the state of West Bengal, and DGP Rajiv Kumar requested, please consider that we put in a reply without notice, seeking permission to file a detailed counter affidavit reply on record, even though formal notice may not have been issued yet, to place the state's full position before the court. The bench responded pragmatically, let it be done in a legal way, indicating that any such filing should follow due process and procedural norms without shortcuts. Senior Advocate Sham Diwan, appearing for Respondent 4 and 5, submitted what has happened is subject to Article 226. Now, January 9 disruption should not have a lingering effect for this court to issue notice. Arguing that the alleged January 9 events already under consideration in the Calcutta High Court under Article 2026 jurisdiction, and the Supreme Court should not treat the brief disruption as a ground to mechanically issue notice or entertain the petition at this stage. In a charged Supreme Court hearing on January 15, 2026, Additional Solicitor General Aishwarya Bhati Raju, appearing for the ED, argued that registration of an FIR is mandatory under settled law once a cognizable offence is prima facie disclosed in the complaint, with no preliminary inquiry or hearing of the accused required. She described the alleged forcible removal of digital devices and incriminating documents from ED custody during the January 8 IPAC raids as a clear case of theft, robbery and dacoity committed in connivance with DGP Rajiv Kumar, an accomplice, and emphasized that Chief Minister Mamata Banerjee, who also holds the home portfolio, cannot credibly oversee any state police probe, necessitating an independent CBI investigation to prevent miscarriage